Robert Clive Jones, born 1947, is a federal district court judge of the United States District Court for the District of Nevada. He graduated from Brigham Young University where he majored in English, accounting, and economics in 1971. Jones attended UCLA Law School where he was an editor of the UCLA Law Review. Jones is a member of The Church of Jesus Christ of Latter-day Saints and has served in several positions in the church including bishop. Bush to a seat on the United States District Court for the District of Nevada vacated by David W. Jones was unanimously confirmed by the United States Senate on October 2, 2003, and received commission on November 30, 2003. In August 2012, Jones held that Nevada's election law giving voters the ability to select none of the above was unconstitutional. One member of that panel, Judge Stephen Reinhart, criticized Jones' handling of the case. His dilatory tactics appear to serve no purpose other than to seek to prevent the state from taking an appeal of his decision before it prints the ballots. Such arrogance and assumption of power by one individual is not acceptable in our judicial system. Sandoval, Jones ruled that Nevada's denial of marriage rights to same-sex couples does not violate the Equal Protection Clause of the U.S. Jones stated that, a meaningful percentage of heterosexual persons would cease to value the civil institution as highly as they previously had and hence enter into it less frequently. He also wrote that adoption is not an alternative means of creating children, but rather a social backstop for when traditional biological families fail. Court of Appeals for the Ninth Circuit reversed Jones's ruling and directed him to promptly enjoin the state of Nevada from preventing otherwise qualified same-sex couples from marrying. However, instead of issuing the order, Jones issued an order recusing himself the next day. In August of 2013, Jones was the only chief judge from each of the 50 states that did not sign a letter to the leaders of the United States Congress urging them to avoid further sequestration-related budget cuts. The letter explained that further cuts would have a devastating and long-lasting impact on federal courts. In a September 2015 opinion, the Ninth Circuit identified Jones as having well-established and inappropriately strong feelings against out-of-state attorneys and directed that the case be reassigned to a different judge due to the appearance of bias. Court of Appeals for the Ninth Circuit criticized Judge Jones in an opinion reversing a decision by him in a case involving a claim for damages by the federal government against ranchers who grazed their cattle on federal property without a permit. The Court of Appeals stated that Judge Jones's rulings in the case were plainly and clearly contrary to law, that he had grossly abused the power of contempt, that he had harbored animus against federal agencies, that his bias was a matter of public record, and that he had engaged in improper treatment of government officials in a previous case. The Court of Appeals stated that it had expressed concern about Judge Jones' conduct in several other recent cases. In remanding the case to the District Court for further proceedings, the panel ordered the assignment of the case to a different judge due to the appearance of bias created by Judge Jones' conduct during the case.